Please remember today to silence your electronic devices. If you wish to testify, you're welcome to do so, but please remember to sign in at that podium in the back. Please also remember that all questions and comments should flow through the chair. And if you have any handouts, you're welcome to have them distributed. Please just ask that one of our pages distribute those to the committee members. We have 3 bills on our agenda today. We're not going to take them in order. We'll take Senate Bill 5 first, then we'll take House Bill 1052, and then we'll go to House Bill 1061. So Senate Bill 5 has had a prior hearing and is now up for discussion or action. Representative Stevens.
Yes, I would move Amendment 5A.
Is there a second?
Second.
Motion made by Representative Stevens, seconded by Representative Pischke to amend Senate Bill 5 with Amendment 5A. Does everybody have that amendment before them? It's on your MyLRC. Okay, discussion on your motion, Representative Stevens.
I'd refer this to Mr. Representative Pischke.
Representative Pischke.
Thank you, Mr. Chair. So we worked with the interested parties. I had some concern about the word custodian when we had a prior hearing. And this amendment would take out the word custodian because we thought that was too broad when you look at the definition. So what this amendment would do would just say that the investigation would happen with a parent or a guardian who is the subject of the child who is the subject of the information or report. So that's what we want to go with. So
thank you, sir. Further discussion on the motion to amend. Any further discussion? Representative Odenbach.
I would ask maybe Representative Pischke, was there any discussion with the proponents of that bill in removing custodian? Was that a problem for them at all, or they were just fine?
Mr. Chair?
Representative Pischke.
Yes, we did meet with the proponents. I forget her name now, but Regina, yeah. We met with her and discussed all this, and they are good with this change.
Further questions or discussion on the motion to amend? Seeing none, the motion before the committee is to amend Senate Bill 5 with Amendment 5A. This is a voice vote. All those in favor of that amendment will say aye.
Aye.
Those opposed, nay. The bill is so amended. We are now on discussion or action on Senate Bill 5 as amended. Representative Pischke.
Thank you, Mr. Chair. I would move due pass on Senate Bill 5 as amended.
Is there a second? Motion made by Representative Pischke, seconded by Representative Peterson to send Senate Bill 5 as amended to the floor with a due pass recommendation. Comments on the motion, Representative Pischke.
Just briefly, I think we had a good discussion. We came up with some. I had some concerns about the bill. We walked through those. We talked about it, and we made some adjustments as needed. I like it now, and so I think it's ready to go to the floor.
Thank you. Further discussion on the due pass motion? Seeing no further discussion, the motion before the committee is to send Senate Bill 5 as amended to the floor with a due pass recommendation. All those in favor of that motion will say aye. Those opposed, nay. Madam Secretary, please call the roll.
Representative Elward.
Aye.
Barthel.
Aye.
Schwab.
Aye.
Odenbach.
Aye.
Peterson. Aye. Pischke.
Aye.
Poirier. Excused.
Poirier votes aye.
Correct. Rayfeld. Aye. Reimer.
Aye.
Soy. Aye. St. John. Representative St. John.
Excused.
Excused. Stevens.
Aye.
Hansen.
Aye.
We have 12 yea, 1 excused.
Thank you, Madam Secretary. That motion carries. Senate Bill 5 as amended will move to the floor with a due pass recommendation. Any objection to consent? Seeing no objection, the chair will certify the bill as uncontested, and the bill will be placed on the consent calendar. Okay, before we move into the next bill, we've been requested by the governor to introduce a bill. The bill is an act to protect the consumer in South Dakota. The chair would entertain a motion to introduce an act to protect the consumer in South Dakota.
So moved.
Mr. Chair.
Second.
Motion made by Representative Peterson, seconded by Representative Soy. Discussion on the motion, Representative Peterson.
Thank you, Mr. Chair. Based on just my brief look at this, it looks like it's a bill that will become more specific as we go through the process, but it is just meant at this point to help us meet our deadline of bill introductions.
Thank you, Representative. Further discussion on the motion? Seeing no further discussion, this will be a voice vote. All those in favor of the motion will say aye. Those opposed, nay. The bill is so introduced. Thank you, committee. Okay. We will move then in our agenda to House Bill 1052. House Bill 1052, an act to provide a rebuttable presumption in favor of joint physical custody of a minor child. We have a busy agenda today. These two bills that are left for the committee will take quite a bit of time, and so we're going to have to limit testimony to 20 minutes of proponent testimony and 20 minutes of opponent testimony. And I would just ask that everybody, in your remarks, which you're free to come and give within the time constraints allowed, keep to the subject of the bill. We're talking about rebuttable presumption under the law. And so I'd ask that you keep the discussion to the legal question before the members of this committee and try to stay away from, sort of histories of relationships and those sorts of things. So with that, the committee will now hear proponent testimony on House Bill 1052.
Thank you. Thank you, Mr. Chair. Good morning. This bill has been something that caught my attention my first year in legislature, and I've spent some time looking at the data, studies, stories, numbers last night, and listening to testimony and debates on this legislation across the country. I'm seeing more than I saw in 2018, 2019. And I thought about a conversation that I had with a legislator from last year. In my first year, I sat across the aisle from Representative Bob Glanzer. And for those that remember Bob, I know we all miss him. The conversation that I had with him was about his work with youth. And one of the things that he told me was that he, in all of his years working with youth, that he had compiled the list of over 30 years of mentoring youth. And he made a point to bring it to me. Here was this handwritten sheet on my desk, and at the very top of it, it said father absence. And we had a long conversation about that because father absence is something that I think is at the root of a lot of things that I see within my community. And we talked about some of the things that, would be that we might do about it. We spend a lot of time talking about the issues that we face related to things like poverty, drug abuse, incarceration, crime, all of those things. And we had talked about what is a crisis in America, that father absence being a crisis in America. So this bill is something that has been important to me personally. It is something that I think we've spent some time. Let me see. The goal of shared parenting legislation is to make sure that a child has equal access to each parent, and asking the court to presume that both parents have a right to joint legal and physical custody, that parents will spend approximately the same amount of time with their children. A rebuttable presumption simply means unless there is a very good reason otherwise. It is important to note that shared parenting is a flexible concept. It can mean that all care is 50-50 or that children spend an agreed percentage of time in one house and the rest in the other. One study found that most families do the fine print of an agreement by themselves. And that's one of the things that I think I was drawn to in this, the idea to encourage the lesser conflict and to allow parents to be able to come to agreements on their own, so that there is no winner or loser in one parent is not the custodial parent, the other the recreational parent. And in states that have passed shared parenting legislation, such as the state of Kentucky, the reports have shown that the law is as effective as it seems to have been popular. The new law's results, according to the court documents that were a part of the study, that caseload in domestic violence cases had previously been rising, but in 2017 that trend abruptly stopped in family court cases, and domestic violence case filings began declining. And in 2017 is when Kentucky implemented the partial version of the shared parenting law. The following July, Kentucky's full-blown shared parenting law took effect, and the family court caseload and domestic violence filings have dropped further. So I'm going to be short with this because we have so many that want to testify and can share some of that information too. So I will leave it to those. Okay?
Thank you, Representative. And Representative, for the benefit of our Secretary and for the record, can you just please state your name and where you represent?
Camera St. John, District 1.
Thank you, Representative St. John. We'll take further proponent testimony. Dr. Warren Farr, are you available? I believe you're muted, Dr. Farrell. Do you have the ability to unmute him? Dr. Farrell, you need to unmute your microphone on your screen. It might be in your upper right-hand corner. You might see a microphone.
Is it unmuted now?
Before you introduce yourself, Dr. Farrell, begin with your testimony. Mr. Meyer, how are we on time?
Mr. Chair, we have 15 minutes left.
Thank you, sir. All right, Dr. Farrell, please introduce yourself and proceed with your testimony.
Yes, I'm Dr. Warren Farrell. I've been doing research on boys, men's, women's issues for, I guess it's close to 50 years now, I'm embarrassed to say. And I was on the board of directors of the National Organization for Women in New York City, probably the leading male spokesperson in the world for women's issues. And I began to discover that there was many teachers were coming up to me around the world and saying, I'm having more problems with my boys and my girls. And so I started to be tuned into boys and men's issues. That started me about 20 years ago on that issue. And I started to look at what problems were occurring with boys and found that for both boys and girls, that there were a lot of problems, like mental health problems that all policymakers were putting their fingers on, and pretty accurately. But then I started asking, well, what was behind the mental health problems, and found that there were two big demographics where mental health problems were significant, very significantly manifesting. One of those demographics was children of divorce that did not have a significant amount of father involvement. And the other demographic was children raised by single moms where there was not a father involved in the process. And so I began to look more carefully at that and ask myself the question, what is needed for children of divorce to be able to have a life that is almost as good or better than children who are in intact families? There was nothing that came out better than, nothing that came out equal to, but there were four what I would call the must-dos of divorce that allowed people, children of couples who were divorced to have almost as good a life, predictably, as children who did not. One was an equal amount of time with mother and father, and the schedule, the specifics of the schedule did not matter. That depended on the uniquenesses of the couple, but the equal amount of time did matter. Number two was that the parents live within about 20 minutes drive time from each other, so that the children didn't start resenting the parent that made them lose contact with a good friend on his birthday, or not be able to attend an activity like soccer, and it allowed for the children to participate in those activities, maintain those social friendships. Number three was that the children are not able to detect any bad mouthing from mom to dad or dad to mom. Number four is that the parents be involved in continuing couples communication counseling, not emergency-based counseling, which only usually made the mother and the father more, with the pressure of time, the mother and the father were usually pointing out the things the other person did incorrectly. But without that pressure of time, they were able to hear each other's point of view, and that allowed for more cooperation between the couple, and therefore the children started seeing a model of better communication as opposed to a model of bad communication, and therefore disconnecting from the normal pattern of children of divorce being more likely themselves to have a divorce. I started looking at some amazing pieces of information. One is the suicide. I saw in COVID, as we all know, the suicide rate is going up. That suicide rate is especially going up for boys. Boys tend to have as good social skills and support groups about expressing their feelings. And the suicide rate for both boys and girls is going up during COVID, but especially for boys. Telomeres. I think you all know that telomeres are what is inside of every cell, and the length of your telomeres are the single best predictor of your life expectancy. I was surprised to see that by the age of 9.5, children who were dad deprived, that is, that had minimal or no father involvement, they were likely to have telomeres that were 14% shorter, predicting approximately 14-15% abbreviation of life expectancy. The telomeres of boys were yet again 40% shorter than their sisters when there was a lack of father involvement by the age of 9.5. The last significant thing that I'll share is the dad brain. I never knew before I was doing the research for the boy crisis that there was such a thing as a dad brain, but I found that there is a whole nest of neurons that when a child is born, for the father that becomes actively involved with caring for that child, those neurons begin to connect and form a sort of like the equivalent of a mother instinct, and with hormones and everything that start adjusting for that father to be much more nurturing, caring, protective, and so on. But if the father interprets the birth of the child as him having to, say, be a national sales rep to sell a product and be away from the child most of the time, that brain does begin to develop, but not nearly as robustly as the brain of a father that's significantly involved with the child. So it was amazing to me to see the degree to which our neuroplasticity adapts to roles that are outside of the traditional roles that I thought were sort of more standard operating procedure. And so I guess the last thing I'll end with is that I was very curious about what was there about father involvement that was so important as a balancing act to mother involvement. I don't need to spend any time talking about the importance of mother involvement. We all know that. But I saw that the significance of dad involvement lay mostly in dad's propensity to do boundary enforcement. Both moms and dads are very good at setting boundaries. They say you can't have your ice cream until you finish your peas. The children are very good at testing boundaries, trying to have as few peas as possible before they get their ice cream. But moms tend to say, oh, I know it's been a tough day for you. I don't want to make the next few minutes about, into a big argument about how many peas you can have. So go ahead. Yes, you can have your ice cream more quickly. Dads will say more likely that we have a deal here, and the deal is that you can't have your ice cream until you finish your peas. Well, the result of that is that the child learns with the dad to focus his or her attention on having to do what they need to do, finish the peas, in order to get what they want to do. That's the formula for postponed gratification. And postponed gratification is the single biggest predictor of success or failure in high school, college, and life in general. And so I know I have a minimal amount of time, so I'll end there and be happy to take any questions.
Thank you, Dr. Farrell. Please do stand by for the question portion later on in the hearing. We'll take further pro-opponent testimony. Ms. Emma Johnson, are you available?
Hello. How How are you?
Good morning, Ms. Johnson.
Good morning.
Please go ahead and introduce yourself and proceed
Sure.
with your testimony. And the proponents have 7 minutes remaining.
Okay, I'll be brief. Thank you for having me and listening to this important issue. My name is Emma Johnson, and I am founder of Moms for Shared Parenting, which is an outgrowth of my work as a single mom blogger. Wealthy Single Mommy has been around for almost a decade now. And I started that as a new single mom of babies and assuming, like most women do in this country, that I was the better parent because I'm a woman and that the kids should be with me. And that was what I saw modeled in my own parents' divorce and in the media, and that's what my lawyer told me was the standard issue deal, and I just stepped into it. And over this past decade, I've done a 180 on that position, thanks to the good work from my colleague Warren Farr, huge bodies of scientific evidence that show that equally shared parenting is what is best for kids. But I'm also in the unique position that I have literally mapped millions of data points from single moms from around the United States and even the world. I believe that mine is the largest platform for single moms. And I just started anecdotally seeing a trend, which is that moms that have equal shared parenting time or close to it, they were doing great in their careers, they were earning more money, they seemed to have better parenting relationships with their kids' fathers or kids' other parents, and it just seemed like it made sense. So in addition to that data and what I just knew what was best for children, I was wondering, could we quantify what is best for gender equality and what is best for moms? Because the party line is that moms really want their kids most of the time. But I wasn't necessarily seeing that in my work. So because of the lack of data, I did my own research just very recently, concluded a poll of 2,300 single moms in the United States, and I found a direct correlation between more equality in parenting time and the more money that single moms make. So moms that have equal parenting time are 3 times more likely to earn $100,000 than moms that have their kids 100% of the time. And that same correlation exists down the income level. There's other correlations between equally shared parenting times. The moms were more confident. They were more relaxed. They reported better co-parenting relationships with their children's fathers. And then even more so, this was what was very exciting and surprising to me. I found that the majority of moms, whether they have shared parenting or not, the majority of moms support equally shared parenting. They want it, even though 51% of the moms I polled had their kids 100% of the time. So this is popular with moms. I was even more excited. I would like to elaborate on what Representative St. John was sharing about Kentucky. I've been following that very closely, the data, and actually interviewing attorneys there and parents and just following the culture there, because that's what's so important. And she is right that the number of family court filings has dropped 11%, double digits, 11% in 2 years, freeing up the courts for families that really do need to be in family court. And the other number is 4%. The number of domestic violence related family courts filings dropped by 4% in just 2 years. That's 700 cases compared to the previous years. So that I think is extremely exciting and compelling evidence. And again, this is all the science. I'm a journalist. I have written for all the major news outlets pretty much, and I am constantly being compelled by and urging others to follow the science because it's very, very clear in favor of equally shared parenting for everyone.
Thank you very much, Ms. Johnson. We'll take further proponent testimony. Mr. Ludwig, are you available? Mark?
Yes. Yeah, thank you.
Okay, stand by 1 moment. Mr. Meyer, how are we doing on time?
Mr. Chair, we have exactly 3 minutes remaining.
Thank you. Mr. Ludwig, we have 3 minutes remaining of proponent testimony. Please introduce yourself and proceed with your remarks.
Yeah, Mark Ludwig, I just need 60 seconds. I'm part of a 900,000 people in the greater shared parenting community around the country. The one point that I want to make is that I get calls on a daily basis from people all around the country that tell me that they didn't have as many problems until they walked into a family law attorney, and the attorney told them that, look, in our state, and this is not a knock on attorneys, this is just a fact, that in our state, we don't get 50-50. And so one of you is going to win, and one of you is going to lose. One of you is going to get every other weekend. So unless you want to be that person, I need you to dig up dirt on the other party or prove to me why you're the better parent. And I don't believe there is a better parent. You know, I may not get along as well with my son's mother, But in his eyes, that's still his mom. And he loves her just as much as me. And he should have a right to both parents. And here's a couple at the most emotional part of their relationship when they're breaking up and needing to move on, and instead they're getting riled up because they realize they're only going to get every other weekend with the child. Imagine how different that would be if you could walk into that same family law attorney and they could say, look, in our state, you're probably going to get 50-50. So you need to learn how to work together for the betterment of your child. I just can't imagine that would not be a better scenario all across the country. So that was the only point I wanted to address. I'll leave more time for others. Thank you very much.
Thank you, Mr. Ludwig. We have 1 minute and 20 seconds remaining. Is there anybody in the room who would like to testify? Good morning, ma'am. Please introduce yourself and proceed with your testimony. Oh, and if you would, please turn your mic.
That was definitely a watered-down version of mine, guys.
Mr. Chairman and members of the committee, thank you for your time. My name is Carla Wild. I am from the Flandreau area, and I am here in support of House Bill 1052. I'm going to keep it short because that's all I have time for, but I would just like to echo everything that was stated already this morning. There's nothing that I can add to that at this point. You're going to hear, we've been here since 2012, every year, and we're grateful, incredibly grateful for how far you have moved the ball down the field, but there are still improvements to be made. And I honestly, maybe it's the age of our kids right now and what we're hearing from them and seeing, but I really don't feel like there has been a more important time for this conversation and for us to move this further. I think our kids are facing a lot of challenges. I think you heard from Dr. Farrell about some of the outcomes when there aren't two loving parents as equally involved in those kids' lives as possible. I've seen it in my own kids. And my daughter, who is now 19, has just started working at our school. And I was talking to her about this last night, and she said, not just from her own experience, but she can now witness it. She's working with kids who are in kindergarten or first grade, and she can tell which parents are, or which kids are struggling at home and whose parents are divorced. I just think it's incredibly important to have both involved as much as possible in their lives, and I know all the rest of the proponents here would echo that.
Thank you very much, Ms. Wild. That concludes the time allotted to the proponents. The Judiciary Committee will now hear opponent testimony on House Bill 1052.
They brought in some ringers on this one, guys.
Good morning, Ms. Miller.
Good morning, Chairman Hansen and members of the House Judiciary Committee. I'm Dianna Miller, and I'm the registered lobbyist for the South Dakota Network Against Family Violence and Sexual Assault. And I think today is kind of an anniversary date for us because I've been up here for the last 10 years opposing this bill and working with negotiations. And as was just stated, we have come a long way, and we have the gold standard of law in custody cases in South Dakota. And I want to stay specifically to the contents of the bill so that I can point out what we object to. The fact of the matter is the judge is the only person who can represent the best interests of the child. You cannot tie a judge's hands with a joint rebuttal presumption and require the judge to have a rebuttable presumption on at least 25 of the guidelines listed in the bill. Those are simply guidelines that a judge will look at anyway. But when you put it in a bill form and you put it in rebuttable presumption, you're requiring that the judge look at that when you're tying a particular judge's hands. Custody hearings, and I think most lawyers and judges will tell you, are the most difficult cases that exist out there. And as I heard today, there are no winners, not mother, not father. The only winner I want is the child, the only winner. So you can't consider it winning as a father or a mother, because by the simple fact they're in court on a custody issue, the fact of the matter is they can't get along. That is the case. They're not getting along. If they were getting along, they would not be in court on a custody issue. They would have filed a parenting plan. And they can do that. However, this bill eliminates that right, makes you go to court, and I have problems with that, and I'll get to that later. Each case in a custody issue is unique and different. Therefore, you cannot start with the assumption of 50-50. Now, the caveat is a judge can start with 50-50 right now under current law. He or she can start with 60-40, 30-70, whatever amount the judge so determines. And I think that's important because when you look at the judge representing the child, you will have a situation where the judge will look at the stability and clarity and expediency of a decision. That becomes paramount to everything because that's what a child needs, stability and to be consistent. The other thing I would bring up that what you look at in the last page of the bill, you look at they eliminate, repeal 25-4A-25. That's in Section 5 of the bill. They also repeal 25-4A-26, talking about no presumption. I don't know why you would do this in this bill. That just adds additional costs to the parties involved. So it doesn't make sense to me to do that. The fact of the matter is, when you look at joint physical custody, I wish we all had ideal situations. And we had a mother and a father and we had a stable situation, but we don't. The reality is this law has worked. And I checked with the Supreme Court, and there have been zero filings on shared parenting in the Supreme Court over the years that we've negotiated changes. So this law is, as current written, is working. And the fact of the matter is, UJS, the Unified Judicial System, also worked on last summer, and in February, or 2 summers ago, February of 2020, they changed guidelines to parenting, and they've worked closely with us to make sure they could provide the best circumstances and recommendations to parenting so that we don't have to go into court. And that should be our goal, to work together. But we can't always avoid conflict. So, Mr. Chairman, I waited to hand out fact sheets at the very end because I'm a former teacher, and the minute you have a handout, people start reading and not listening. And it's important that we listen when we're in a classroom. But I didn't want to go into all the other states. I have presented a fact sheet of all 50 states.
She definitely does, Stephen.
Thank you very much. Pass out that you can read it and look at it and check on other states, because currently there's only one state mentioned, but we can't get the data from Kentucky that went to joint custody because of we called and asked about the domestic violence issues, and they said they could not give us any updated data. There are 38 states that deal with the best interests of the child. And the fact is, South Dakota needs to retain this particular bill. So I would ask respectfully, Mr. Chairman, that you...
Yeah, I'll get a copy of that fact sheet, Taryn, and I'll distribute it to all the leaders of all the organizations.
Mr. Meyer, how are we doing on time?
Mr. Chair, we have 14 minutes, 13 seconds left.
Thank you. The committee will hear further opponent testimony on House Bill 1052. Mr. Siegel.
Oh,
Good morning,
great.
Mr. Chair.
I remember him.
I'm Steve Siegel, and I'm the registered lobbyist for the South Dakota Trial Lawyers Association. We, too, rise in opposition to this bill. And I'd like to say, first of all, I understand where the proponents are coming from. My wife and I have 3 kids, and we've been married for almost 25 years, which is a small miracle in and of itself. But
yeah, I'll get you a copy of that, Charles.
And I understand they're very tough issues, and I feel for these people that are here, and I understand they're here for a reason, and I don't take that lightly. But
yeah, this guy's a very well-known, high-priced lobbyist in South Dakota.
Not the best interest of the mother or the father or mom and dad together. It's the best interest of the child. I think most trial judges in South Dakota will tell you it's not a good idea to start with a rebuttable presumption. It's just not a good idea. We should listen to our trial court judges.
Yeah, send me a private message, Junior.
They have experience.
I'll get you one.
These hearings. They understand what works and what doesn't work. And the vast majority in South Dakota will tell you it's not a good idea to have a rebuttable presumption. I don't do a lot of family law, so I talked with a number of our members that do. And these people are representing moms and dads. I mean, it's not just lawyers that are representing moms, but the vast majority of those lawyers think that this is a bad idea. They say that the procedure's already in place for shared parenting. I mean, it does require cooperation, but the procedure's in place. My son used to be a hockey player, and he had a teammate on his team whose parents were divorced, and they had 2 sons, and they did a great job. They had shared parenting, and it worked really well. Now I understand that's an example of parents that cooperate, and a lot of the people we're talking about don't have cooperation from one of the spouses. I get that. But the fact is the procedure's in place to do this already. We don't need a new law. We can do shared parenting with the statute that's in place. It just requires cooperation, and frankly, it requires the parents to think about what's in the best interest of the children, not in my best interest.
Guys, what I'll do, I'll post it on the website for everybody who wants
Professor
copies of that.
For family law.
That way everybody can just download it.
Lawyer, but he said joint physical
It'll probably take a week or so to make sure that we get it and get it up there.
Because the child is constantly going back and forth. He's being pulled back and forth between mom and dad. His opinion was it was better to have a home base for that child where he felt like that was his home, and then visitation for the other parent. He felt that was in the best interest of the child. So I say today, let's listen to the trial judges. Let's listen to the family law professors. Let's listen to the South Dakota family law lawyers that practice in this area.
The ones who are making money off it.
Procedures already in place, and we should be thinking about good public policy up here and not individual mandates. And for that reason, I would ask you to please vote red. Thank you very much.
Thank you, Mr. Siegel.
Unfortunately, he carries a lot of clout because he controls a lot of the contributions to campaigns in South Dakota.
1052.
Which is why he was there in person.
Mr. Chair, we have exactly 11 minutes left.
Thank you. Ma'am, welcome. Please turn on your microphone, introduce yourself, and proceed with your testimony.
Mr. Chairman and members of the committee, thank you for this opportunity to speak today. I'm April LeBeau from Oklahoma, South Dakota. I'm the mother of 7 children. My oldest is 31, my youngest is 10. When I was a child myself, my parents divorced, and I became a child whose needs were second to my parents' wants, and I remember the heartache from a child's perspective. It would have been great to have the type of parents that truly had the best interests of their children in mind. However, the reality of it was that my brothers and I were nothing more than pawns in a custody chess game between 2 parents where there was never a winner and the biggest losers were the kids. Shared parenting won't solve a thing for 2 parents who already can't agree on anything. One parent might want the child to be involved in certain activities, while the other parent might not want that. It'll be an ongoing battle between bickering parents with the child caught in the middle. Imagine that you're a 10-year-old who wants to play baseball, and the only teams in rural South Dakota are the traveling teams. Your mom is willing to drive you back and forth across the state to all of your games 50% of the time while you're with her, but the other 50% of the time when you're with your dad, he can't take you because it conflicts with his work schedule or money is tight, he can't afford it. So you miss half of your games and then you're benched and you miss out. Then your mom is mad at dad for not taking you, and dad's mad at mom for signing up for an activity that she knew would be impossible for him. And you're not only left out of the activity you love, but even worse, you're caught in the middle between unhappy parents, and you know that they're fighting because of you. And what about the families that have 2, 3, 4, 5 children, all of different ages? Shared parenting might work for the younger kids, but the older kids have school and sports and church and crazy schedules. And this is hard to manage with one household, let alone 2. And then for all these parents that can't get along to start with, let's pretend that shared parenting would become law. Not only would the kids not have the stability of one home and one bedroom, but in many cases, one parent would say things like, those belongings of yours have to stay here at my house, and you can wear that and play with that when you're here, but you can't take that to the other parents. And I hear this with people that I work with, and I always feel for the children. What about the parents who live many hours apart? Like one parent might live in Aberdeen and the other in Rapid City, and how is that supposed to work? How would you like to be the child who is traveling that distance 50% of the time? For many kids, that many hours in the car seems like torture. Are parents who already can't stand each other going to be forced to live closer together if this law is passed? If that's the case, that adds numerous issues like jealousy and stalking, etc. between angry parents. There will be more instances of one parent accusing the other of not being good enough. For example, one parent might see the other out with a new partner, and that would be ammunition for the argument of, I saw you out with so-and-so, the kids are supposed to be with you, and where are they, and how come you weren't home with them, and so on and so forth. Shared parenting will never be enough in many cases. You'll still have the parents that'll dig for whatever dirt they can find out about the other. They'll dramatize every little nitpicking thing and even go for full custody simply to hurt the other parent. Kids will suffer even more.
Yes, I'll post that information too.
I spent over 20 years in abusive relationships. Domestic violence happened sometimes daily during that time. My abusers were never convicted because I never told. I was too scared to report to law enforcement because that would mean more punishment for me. And to see in this bill that there has to be a conviction or a history of domestic violence is very frightening. Most abusers are never convicted. Most people will never know how abusive some of these parents are behind closed doors. If this bill passes, many children will be forced to spend 50% of their time with an abusive or neglectful person that happens to be a really good actor in front of public or in front of a judge. I'm the executive director of the Missouri Valley Crisis Center in Chamberlain. Everything I just read are examples of what I've seen firsthand and on a regular basis. I'm currently working with one victim who found the courage to leave her abusive and controlling husband 3 years ago. They had 2 children together who are now only 7 and 4 years old. There's never been any drug or alcohol abuse, no neglect, nothing by the mother. In fact, she was a stay-at-home mom and devoted her entire life to raising her children. Her ex was very controlling and still is. Immediately after she left the marriage, he bullied her, and she agreed to a 60-40 custody agreement with her being the 40%. And she is somewhat a timid person and just agreed. Since then, he has taken her back into the courtroom 28 times to amend their custody to take more time, more mother-child away from both the mother and the child. 28 times in 3 years. He even moved to a different state with the children in hopes that she wouldn't follow. She did follow, and this upset him further, and he's continuing on with his reign of control. She's flat broke because every penny she gets goes to the child support or her legal fees. He has one agenda, and that is to destroy this woman. In many cases, shared parenting is not about anything except for control. I'm not against shared parenting cases where the arrangement works. However, reality proves that it does not work for every situation. Let's not make it the only custody option in South Dakota. Every family, every situation, and every child is different. Let's respect our children and keep flexibility and options in custody agreements available. Please, for the love of our children, vote no on HB 1052. I agree that the system is broken, but a shared parenting law.
I agree, Charles. 50-50 would be better in that situation.
Ma'am, can you please state your last name again?
LeBeau.
LeBeau.
L-E-B-E-A-U.
L-E-B-E-A-U.
Yeah.
Okay, thank you very much. Mr. Meyer, how are we on time?
Mr. Chair, we have exactly 5 minutes left.
Thank you, sir. The committee will now hear further opponent testimony on House Bill 1052.
This is Lindsey Thompson, and I'm calling in, and I don't have the video brought up, so I don't know if and when I can get in to testify as a opponent.
Okay, Ms. Compton. Just a reminder, you have 5 minutes remaining in opponent testimony. Please introduce yourself and proceed with your testimony.
Sure, I'll try to keep it at 4. Good morning, everybody. This is Lindsey Compton. I am currently Executive Director of White Buffalo Calf Women's Society here on the Rosebud Indian Reservation, and we are reaching 43 years in service as a historical first shelter in Indian country. And so this is really unique to where I think even the proponent and opponent both agree that, I'm an advocate for women, but I'm also an advocate for families and men, and knowing the importance of the father's role. I don't think any of us are ignorant to the fact that children do better and are more healthy and are more well-rounded with both parents, both sets of families in the life. In fact, I would like to...
Ms. Compton, yeah? I'm sorry to interrupt, but we're just having a bit of a hard time hearing you. Can you please try to speak up?
I will. Let me take it off speaker. Maybe that will help. Is it a little bit better?
That sounds better already. Yeah, thank you.
I apologize for that.
That's okay.
So I think that we both agree, proponent and opponent, that having both parents, both genders, both role models, both sets of family is the ideal situation. That's not the reality in the majority of the cases, and in particular in the cases that have domestic violence, have a history of violence involved. The proponents kept quoting statistics and ideas from Kentucky and their law, that DV went down. And I want to be really, we need to be wary of those statistics because they don't really tell the true story of the survivors and the victims. Those could have gone down. The DV and SA rates could have dropped due to women not wanting to report because of that law, because of knowing when I report this and potentially go through a divorce, that my children are going to automatically be 50-50. We operate at the shelter here, 90 to 100% capacity, 24/7. We're one of the only culturally responsive shelters within a 300-mile radius where we have 24/7 staff, and we operate all the time, 100% just about. And it's almost daily that we see women, victims come in, scared, frightened of going through a divorce, or scared and frightened that the father will get custody. And I think the points, the 25 guidelines that judges are able to help make the decision, because each case is so individual, are great parameters and guidelines for those judges with their experience and with the unique cases in front of them to be able to help the parents in the decision and award. And oftentimes, it just because it's not 50-50, we see cases of 49-51 to where it is so close, but just basically one parent or the other has that extra percent to have some legal standing as opposed to the non-custodial parent. In particular, I also wanted to, the points that the doctor made was very, very good, but that really doesn't, that reflects the individual father's parenting and their own choice of involvement. That does not reflect the court's decision to make it an automatic 50-50. In particular, with very young children where you have breastfeeding babies, how is the judge going to, or the court's automatically going to insert that right where, maybe the bill can be revised or some revisions can be done to have some resources to get parents into mediation a bit further, as opposed then a better decision can be made and taking time considering each individual case. Is there violence involved? What does that look like? Each parent's resources. If we have a mom who stay at home but doesn't work and needs to go to court, or is trying to leave her abusive or just even toxic marriage, what does that look like? And it keeps people. We already know that families and couples stay together in the name of the kids. Women don't report. The majority, 99 to 100% of our victims, myself included as a survivor, did not want to leave their abuser because we want that father there. We want the father to our kids there. We want a family. And it is not the reality of some individuals who can change and make that healthy. And just because the judge, or not even a judge, the court of South Dakota, which I don't feel is, we need to give people, let them keep the rights to be able to make their individual decisions in particular, and not be having oversight into these sorts of variety of cases. And it's very difficult already with what is in place. I think it really speaks to the nature of our judges' experience and having those guidelines to be able to help discern the best needs of the child. And I had spoken before in a bit more personal note in 2018, and I would rather speak on the exact sort of data and the trends, and as a survivor myself, the reality what that looks like. And I just wanted to thank you guys, and I really feel like this needs to go back and be revised, and how can we provide more resources to the family and mediation as opposed to automatic 50-50. Please vote no on this particular, more decisive bill for families.
Thank you very much, Ms. Compton. That concludes the time allotted for opponent testimony. We will allow the prime sponsor time for rebuttal. Ms. Wild, welcome back.
Thank you.
Please keep your remarks to rebuttal testimony.
Okay.
And would you please just reintroduce yourself for the record?
Sure. Again, my name's Carla Wild Wilson. I'm just going to go through a list of things that I heard, and a lot of these things are discussions we have every year on this bill when it comes up. The one thing specifically that came up in the beginning is that the judge is the only person or the best person to represent what is in the best interest
of these children that they see. I'm not second guessing the work and the value of the work that a judge or an attorney does on any of these family law cases. I know they are some of the most difficult to work with, but I would defer to all of the social science studies that have looked at this issue, as well as the families going through these cases, to say they probably know their kids better. And it's not an easy time ever when you're going through a divorce or separating and trying to figure out what is in the best interest of your child. So it's great to have help. It's great to have guidelines. But everything from any of the studies that have been done on this over the past 12 years, in particular since 2014 and subsequent studies since, and these are dozens of studies. This isn't just a couple, a handful, and it's not just men looking at this, it's not just women, it is an incredibly broad community that has looked at this issue. Everything that is in this bill is done in the best interest of the children. That is the focus. And so I guess I kept hearing that come up in the rebuttal testimony. This isn't about what's best for mom and dad. Fortunately, what the studies also show is that when this is the norm, when you walk in and you're asking for somebody to help you decide what is in the best interest of your children, and this is the standard, it tends to reduce all of these other issues that there are concerns about. There are facts backing that up. I know that our opposition had a stack of papers up here. If I would have brought all of the studies that show to the contrary that this is in the best interest of the child, we would have had a stack of papers, equally if not higher. It does not tie the judge's hands. This still gives them a latitude of decision-making opportunities and resources to make those decisions. It does not tie a judge's hands. The bill does not eliminate the ability for parents to file a parenting plan. I believe that comment was made. In 2017, there actually was a case, Siegel versus Siegel, that was filed with the state Supreme Court, where the judge did overturn the lower court's ruling and granted a father joint custody. So there has been a case, but honestly, and speaking from personal experience with my own husband's case, it's we kind of were joking about it this morning, and I don't know that joking is the right term, but it's like going into a casino right now, taking any of these cases back into a court. It's a gamble, and you don't know, as the parent who's been granted far lesser time, whether or not it's going to pay off, and how many thousands and thousands and thousands of dollars do you go in to try and spend to do what you believe is in the best interest of your children and that your children may actually want. But there's no guarantee that it's ever going to net you what you're going in for. And so it wasn't surprising to me to hear that statistic, honestly, that there haven't been many at all that have gone to that level. Because when you make something so difficult for someone to want, who has every intention of being involved and being a loving parent and wanting to be there, and it's impossible for them at every turn, and it costs them a lot of money and they never get anywhere with it, how far do you keep pushing that before you walk away? And again, I think one of the other things was, that this causes more problems for parents to be on equal footing. The studies just show that that's not the case, time and again. I think two other things that I noted. Yeah, I think that fairly covers it. Sorry.
Thank you very much. Did I say your name wrong? Is it Wilde Wilson?
I think I just said Wilde the first time, but
okay.
Yeah, my maiden name's Wilde. My married name is Wilde Wilson.
Gotcha. Thank you very much.
Yep.
Appreciate your remarks. We will now close public testimony and open up to questions from the committee. Are there any committee questions? Representative Poirier.
Thank you, Chair. I just have a question for whoever can best answer it. On the first page, line 22, may the finding by the court that the parent has a conviction or history of domestic abuse. A conviction was inserted in there, so the parent has to have a conviction or history of domestic abuse. Why was that important to add into the code?
Representative St. John, or anybody willing to answer that question? Representative Pischke.
Thank you, Mr. Chair. We added conviction into that language, felt that was important. Obviously, conviction is a higher standard, but history doesn't necessarily have to be, convicted of the crime. I think it's important to have either or, so that's kind of what we were going for there. Personally, the discussion was had when drafting this legislation to just put as conviction, but we thought that was too stringent, so we left both options in there.
Follow-up, Representative?
I do have a follow-up, but I have a separate question.
Okay, go ahead.
On the third page, line 3, and this is to whoever may answer it, it states that the sentence is stricken. The sentence that is stricken from the code is the joint physical custody arrangement is in accord with the child's wishes, or whether, and so the child's wishes is stricken from the code, so it would read whether the child has a strong opposition to joint physical custody. So my question is, why would that be stricken? I mean, I'm hearing from both proponent and opponent the best interest of the child, both arguments, and I just would like to know, why is the child's wishes not relevant to the code?
Representative Pischke.
I'll try to answer that one as well. That's more of a LRC update. It's just making that factor read better. So I think it's really trying to get the same essence of the factor, but just clearing up the confusion in that language. But if you're strongly opposed to it, we can certainly amend that.
Follow-up, Representative Poirier.
So this would just take out the child's wishes out of the factor, correct?
Representative Pischke.
I think when you say whether this child has a strong opposition to joint physical custody, I think you're taking into consideration the child's wishes. I think that covers that.
Follow-up, Representative Poirier.
Okay. I have a follow-up to the domestic violence issue, if you would like.
Mr. Farrell, we'll just hold on any more public testimony. If somebody has a question for you, they're free to ask. So please do stand by. Further questions from the committee, Representative Pischke.
Mr. Chair, thank you so much. I actually did have a question for Mr. Farrell. Let me get back to that. Mr. Farrell, one of the opponents that came up here today talked about a child going back and forth from one parent to the other if they're in a shared parenting arrangement. They didn't feel like that was in the best interest of the child. Could you maybe talk to that? Do you have any information that you could share with the committee if that is detrimental, or just kind of talk to what your studies have found if that is detrimental to the child?
Yeah, it does not appear to be detrimental especially if that back and forth is within 20 minutes. But what I found was that in other words, 20-minute drive time, so that there's not that loss of activities and friendships from the going back and forth. So what I basically found is that the research showed that that stability on the part of the child with the parents parental stability is far more important than geographical stability. The children that have both parents easily seem to be resilient and adjust to the parental going back and forth between the parents. That was something I was not sure about when I began my research, but it was very, very clear in the research.
Thank you, Dr. Farrell. Follow-up, Representative.
Mr. Chair, thank you. Not a question, but just a comment to the committee. If you do notice in the language, the factors on page 3, line 11, or factor 11, the geographic proximity of the parents is one of the factors that the judge has to consider when making their determination. So, based on what Mr. Farrell is saying, that if they're within 20 minutes, they can keep their friends and the relationships between each other. So that's something the judge already has taken into consideration. Thank you, Mr. Chair.
Thank you, sir. Representative Reimer.
Yes, this question will be for Ms. Miller. She had stated that she has seen this bill for 10 years, and you said we've come a long way. What does that mean? What changes have been made?
Mr. Chairman,
Ms. Miller.
Dianna Miller, representing the South Dakota Network Against Family Violence, Sexual Assault. It started with an initial bill, and I'll give you a little bit of history as quick as I can. At that time, Senator Dan Lederman brought the bill, and we negotiated with him on some changes to the child custody law. Then State Bar President, Executive Director, at that point, Tom Barnett, and Representative Pischke, and I negotiated the 25 factors that you see brought in there that a judge may consider. That was one of the significant changes. And then there was also some significant changes on notification, I believe, that we put in. And that would be the home study evaluations, custody evaluators. We got UJS involved to do training, develop guidelines, that type of thing on custody, child custody evaluators to make that clear. And then we talked about, I believe, findings of fact and that kind of thing and filing of that, but not based on a presumption or a rebuttal of presumption. So we've made modifications throughout and I would say, I can't remember the exact year now, I think it was 4 years ago that Tom Barnett and Representative Pischke, but I could be wrong on the time frame, made changes to it, significant changes, and they accepted them at that point, Representative Reimer.
Follow up, Representative Reimer?
No, thank you.
Further questions from
Thank you.
Ms. Miller. Representative Rapel.
Ms. Miller, I have another question for you, please.
Not so fast.
Mr. Chair. Do we have any data on what percentage of divorces or relationships that have ended due to verbal or physical abuse? And if so, how many relationships are potentially in those kind of environments and not known? Do we have any of that kind of data?
Mr. Chairman, thank you for the question, Representative Rayfeld. And I'm going to have to tell you we don't have accurate data on all of that because obviously I could phone a friend here and give you some history that we have of some data on domestic violence occurrences. As you heard some people talk about, they don't file necessarily for domestic violence charges because domestic violence sometimes is a power and a control issue. And so we don't have the figures and statistics, and I'll look back here. Is that correct? That I got from my phone a friend, the executive director of the South Dakota Network, is shaking her head at me, and that's correct. Unfortunately, I'm sorry we don't. I wish we had more accurate information for you on how many domestic violence is involved in custody cases and how the children are involved in that as far as statistics. I apologize, Representative Rayfeld, but I don't have that data.
Thank you. I have a follow-up question, actually not for Ms. Miller, but for Dr. Farrell.
Yes. Go ahead.
Dr. Farrell, I have some questions in regards to your sample sizes and where you're getting your sample population for your studies. I don't believe I heard that in your testimony. I guess what I'm looking for is what states is this information coming from, and what are the current statute within those states that you're getting these sample sizes from?
Yes. What I did is gathered research from all the peer-reviewed researchers around the world that had done the most responsible studies. And so, for example, Dr. Warshak wanted to have the exact answer to your question as well, except for the states part of it. And so he went to 100 researchers at academicians who usually, as you probably know, don't agree on anything, and asked them to look over the data on equal shared parenting versus not, and got what ended up being called a consensus report the consensus report was that 100 of the researchers and the psychologists out of 100 had a consensus that the children do best when they have at least 40% of the time with the other parent, but they do it increasingly better when it goes up to 45, and even better when it goes up to 50%. And so those were from all around the country, but many of the studies were also from Canada. Many of the people and Europe, many of the some of the experts that he consulted and that examined the data were from other countries. So the research in that I allowed an appendix of the Boy Crisis book to be circulated to the committee, and the summary of the research is the 50 plus areas, major findings about the ways that children do best in shared parenting situations. And again, I did not start with that point of view. When I was on the board of NOW, I presented some of the original data to them, and it was made very clear to me that I would not be receiving the number of speaking engagements that I was in the past if I persisted on presenting this data. So this is really so overwhelming in this direction that it's that all 50 of the outcomes from many different methodologies and mostly meta-analyses, meaning that there are analyses of multiple studies that are with different methodologies from different states, different countries put together, and this is it's one of the rare things that, as I said, that the evidence is so overwhelming that you can get 100 researchers and psychologists with practical experience working with families to agree on anything like this.
Follow-up, Representative Rayco.
Yes, please. Mr. Farrell, I guess my question is does any of your data come from a state that has current statute like what we're proposing here, where there's a presumption of 50-50 custody that is the law? Does any of your data come from that?
Very little, because that's so not the case until Kentucky occurred. There's been the data includes areas of the country where there is much more likely to be that joint that assumption, but that's incorporated in the larger data.
Thank you.
Sure.
Further questions from the committee? Representative Odenbach.
Thank you, Mr. Chair. I guess this question would be for the proponents of the bill. Whoever might want to answer it is wondering if passage of this bill would equate to a substantial change in circumstances to allow all aggrieved parties that have current custody orders to go file another petition for rehearing and start that up again because this passed, and then I'll have a quick follow-up.
Representative Pischke.
Thank you, Mr. Chair. I've heard that concern before, and that's why on Section 1 it says, upon a petition of either parent for the initial determination regarding physical custody of a minor. So, no, we do not want this to be a change in circumstances. We want this to be only applied to an initial determination.
Follow-up, Representative Odenbach.
Mr. Chair. I'm just going to read here from another attorney that I respect a lot who'd emailed me in response to a question. And he said, well, this applies in any custody dispute between parents if a parent requests it. House Bill 1052 modifies 25-4A-21 to strike that language and apply only to the initial determination. So our current joint physical custody statutes would no longer apply to motions to modify custody after the initial determination. So parents who are not initially suitable for joint custody but who eventually get their stuff together would not be able to use these statutes. Can you address that basically if this passed, the initial determination would have been set under what we're going to do here, but then they wouldn't be able to go back in if they later on want to go in under a changed situation?
Representative Pischke.
Well, I'm not a lawyer, we all know that, but I guess that's not the intent of the legislation. And so if the lawyers in the room can help me with that, I'd be much obliged. But that's not the intent, is that any new person or person going back that have already had their determination of custody already determined, I don't want the passage of this legislation to open up the floodgates. So I thought that's what we were trying to do in previous years, and so if we can make that clear through the process, I'm more than willing to go down that path as well. Maybe that'd be another section that we need to add, say, with the passage of this legislation.
Follow up, Representative Ludwig.
Mr. Chair, I don't know if now at this late hour is the time to try to do that, but it's just an issue I wondered if they'd want to address. It's one of many questions that have arisen as I've wrestled with this bill, maybe more than any others over the last few days and weeks. So I'll maybe have some more comments in the comment portion of this. Thank you.
Thank you, sir. Further questions from the committee? Representative Pischke.
I'd like to ask a question to Emma Johnson, if she's still on.
Ms. Johnson, are you there?
Hi, I'm here.
Hi, Emma. I'd like to, if you know, could talk to the domestic violence numbers in the state of Kentucky. I know that Kentucky passed a presumption in 2017 for temporary orders, and then passed a law in 2018 for permanent custody proceedings. Could you talk to the numbers of domestic violence, if they're going up or going down since the passage of this legislation?
Right. Again, can you hear me okay? Yeah, again, it's what I was saying earlier, which is that the numbers have gone down 4% over those 2 years, which equates to approximately 700 cases. And so in speaking to lawyers and experts and getting a read on that state, it's a mixed bag. I mean, look, couples are incentivized, and sometimes explicitly so, to file false claims. That is a known fact. Number two, the tension and the conflict escalates when people are splitting up. That's been stated, that we all know that. That's a fact. And again, I'm going to reiterate what's said again and again here, which is when we take the fight out of it. As it stands now, again, it's true across the country. It is a standard to set couples up to fight and bicker over these often small amounts of time. We heard about cases where it's 49-51%. If we take that incentive out, the conflict is lower and people just accept it as normal. I'll just share with you, and so when that conflict is taken out, then we have less cases of violence. And there are some studies out there that show that there's a single case of violence that occurs statistically at the time of the breakup of the relationship. And so if we are lowering the conflict, then we're lowering the violence, and we're lowering the filings, which is a wonderful thing for domestic violence victims, because it frees up more space, more resources, more judiciary resources to serve those clients that really do need to be in court, that really do need to have a creative and thoughtful custody experience. So I hope that answers your question. There is one more point, if you will allow me to exercise addressing a question about the back and forth. I'll just tell you about my own personal family now. When we did the every other weekend Wednesday night special deal with my ex-husband, I have 2 kids who were basically babies when I got divorced. Count the number of times that's back and forth. It's twice on Wednesday, 2 more times. It came out to 8 back and forth on a weekend, on 1 month. 8 back and forth on a month. Now we do 1 week on, 1 week off. And the kids, when they used to go to school, they would go to school on a Wednesday, or say on a Friday, let's say from my house. Their dad would pick them up from school on that Friday. They'd stay at his house all week long, go to school the next Friday. There's basically, it turns out to be 2 to 4 back and forths a month. It actually lowers the back and forth. And I can tell you, it is so much smoother. They have a routine. It is just an easy, low conflict, natural way for.
Thank you. Further questions from the committee? Are there any further questions?
I'm sorry.
Representative Rayfield.
I have a lot of questions. Thank you. Appreciate it. Are there any other states? I'm hearing Kentucky. I guess I need a point of clarification. Which other states have language like the language that we're proposing?
Does anybody wish to answer that question? Sir, please introduce yourself and then you can proceed.
Spencer Reitzman, Sioux Falls. Currently in statute, Kentucky is the only state that has it in codified law, but we also have 14 other states that are currently running bills through the House and the Senate, and there's 4 states that are very highly likely to pass almost identical legislation during these current sessions.
Thank you. Follow up, Representative Rayfeld.
No, thank you.
Further questions from the committee? Are there any further committee questions? Representative Poirier.
I have a question of whoever may answer it. As the law stands right now, are we not able to do shared parenting?
Ms. Miller.
Mr. Chairman, thank you. Dianna Miller, representing South Dakota Network. Currently, you're able to do that under current law. Yes.
Further questions?
I would add one other thing. And a judge can decide joint parenting also under the law, wherever he or she wishes to start. So it can currently be done.
Okay, guys, just to give you an idea of what to listen for in the next minute or the next 2 minutes. Representative Odenbach on the left-hand side is probably going to make a motion to table the bill to the 41st day.
But as she also stated earlier in her testimony, some judges start off with a 70-30 presumption. I mean, it's all kind of whatever the judge decides with them. So this legislation would give directive to the judicial branch is that we're going to start with the presumption. And so we would take away some judges starting with 70-30, some judges starting with a presumption of 50-50. This adds clarity to what the judge's job is supposed to be. Thank you.
Okay, real quick. So Representative Odenwald is going to make a motion to put the bill on to the 41st day. There's only 40 days. So
No further questions. We'll move to committee discussion or action on House Bill 1052. Discussion.
if he doesn't make that motion, that's what we're hoping for. Then we get to vote on the bill itself.
Representative Stevens.
I move to have this bill sent to the 41st day.
That's what we were looking for.
Motion made by
Shoot,
Representative
that's
Stevens,
not good.
Seconded by Representative Poirier to send House Bill 1052 to the 41st legislative day. Comments on that motion?
There's only 40 days in session. So we want this to vote
When
no.
I first got into this legislature, my wife asked me this question: what are you going to do when you got a good friend?
If we get more yays than nays on this vote, then it's tabled for this year.
I'm going to get a button that says, I really like you, but I don't like your bill. And that's kind of where I am at today. You know, I know this is really an emotional bill, and I haven't been up here for all 10 years, but I think I've been up here 8 years. And you know, some of the material I heard, quite frankly, is missing the point. The point of this bill really is, and I think the good representative from District 35 and I agree on, is, you know, what's really the impact of rebuttable presumption? That's really what it is. Because, you know, I don't really think there's an issue about the importance of parental involvement with their kids' lives. Nobody's arguing about that. The question is rebuttable presumption. And I don't think anybody's got an issue with, you know, nobody's up here arguing is a woman or a man a better person to be the parent. That's not the issue either. It's about rebuttable presumption. And, you know, it's not about the science. It's not about the studies. You know, as parents, we know our kids better than anybody else does. And so that's not the issue. It's about rebuttable presumption. And it's not about winning or losing. And quite frankly, this bill is not about whether you agree upon shared parenting or not. You know, it's about how it impacts a judge's decision when they're trying to determine the custody of the child. That's where the focus really needs to be. And so it's not about those issues. You know, I've been practicing law for 43 years, and I don't claim to be an expert, but I will tell you this. I've tried more custody cases than anybody else in this room. You know, I've represented men, I've represented women on this situation, and these are the most contested and they're the hardest cases to have to represent, regardless of what side that you're on. It's just really difficult. You know, you feel for your client. Quite frankly, I felt really sorry for the other parent as well, and I feel really bad about the kids, because no matter what laws we pass, the kids are always in the middle. They're the ones that are always being torn, whatever decision. And I will disagree with my good representative from 35. I don't believe the judges no longer start out 70-30. I really don't. I think the laws and the work that you have done have been it where it is the best interest of the child, and they start out at the starting line. Everybody starts out at the starting line. These bills are expensive. Right now, for those of you who don't understand, when someone comes in who, because we're talking about a contested case here. We're not talking about the case where the parties come in and say, I agree upon that. And I will say over the years, I've seen a real trend where more and more parties are coming in. They've already got their agreements worked out, their parenting plan. We type it up, we send it to the judge.
Yeah, Dwayne, he's been paid
We're talking about people who
quite a bit.
Don't get along. It's a contested matter. And for whatever happens before, what happens before it ever gets to a judge is this, is that the judge has the authority right now to order the people to mediation, to try to see if they can work it out. And if that doesn't work, then they order them to go and get a home study. They go to a professional who goes and examines the people, goes to their home, interviews witnesses, all of those type of things, and puts all that information together before they ever see one day in court as far as the actual decision is concerned. Why I'm against this bill is what's this going to do is it's going to add additional costs to people. It's going to result in clearly more appeals. And I think what you need to understand on this thing is this. I represent both men and women. So it's not a deal where I'm representing one side or another. In fact, I've got more cases now where I'm representing the fathers than the women. So this isn't a gender kind of a thing. And I think when someone asks about what the history of this is, what I think you really have to understand is this history goes way back into the early 80s and the early 70s. Because in that point, when I first started practicing law, this is what the law was, is if a child was of tender years, there was a presumption that it had to go to the mom. And when it got into the teenage years, there's a presumption it had to go to the dad. And we found that wasn't fair. That wasn't right. And I actually took a case in the early 80s where I represented a young man, and we got custody of a 6-year-old daughter. I mean, that was just unheard of. But the judge based upon what was in the best interest of the child. And soon we got rid of the tender years doctrine, and we came back to where the law is now, is the best interest of the child. And over the years, and I will give credit to my good friend, representative from 35, on some of his work, he has brought up these issues. We have, and I pass these around if you want, SDCL 25, 4A, 24, factors for consideration on request for joint physical custody. And as a result of his work, the judge has to look at every one of these, I think there's 23 of them, criteria, before they make a decision about what is in the best interest of the child. So right now, the judge has, before it has a home study. It hears all the testimony. The court then has to take all that testimony and make sure that he has heard all of these criteria here before he gets to the point of making a decision of what is in the best interest of the child. So what does just a couple of words, rebuttable presumption, really do? Well, it changes everything. It really does change everything. And the good representative, I can never remember from around Lawrence, who brought up the question about the lawyer, he made those comments, I think, are right on. I think it's going to throw everything up in the air. I don't think it accomplished, I know what you said, what your intent was, and I believe you, but I don't think it quite frankly, I don't think that it does that. But it's going to impact the judge's decision. Rebuttable presumption is a big word. It's very, very significant, and it does change everything immensely. It changes the focus. Where the focus was on the best interest of the child, I think it does two things. It changes the focus back to the parent, but it also does one thing else too. It creates a burden. It creates a burden that shouldn't be there. The language of the court, in order for the court to undo this presumption, is it says it has to be substantial and credible evidence. And I don't know what that means. After the judge has got a home study and has heard all the testimony, has had to do all this, then he has to find by substantial and credible evidence, which adds a new burden and a new level that you have to look at in order to make this.
That's Representative Stevens, John.
There's really any testimony preserved. It's kind of like this. it puts the party who may not want shared parenting in a disadvantage. They're not starting at the starting line at the very start. What they're doing is they're back. If you put this in kind of like a football game, when the football game starts, one party has already got credit for a touchdown. They've already got some points. And so from that standpoint, I don't think we're at a point where we need to do that. I think that we really are at a place where we have a golden standard.
Well, real quick, while he's rambling, guys, the motion's on the table right now to move this to the 41st day of the calendar. In South Dakota, there's only 40 days of legislation. So that's what the opposition normally does to kill a bill. So if they get a second to the motion, which when he gets done talking, I'm sure Odenbach is going to second that motion, then they're going to vote on the motion. They're not voting on the bill. So what we want is that motion to be killed. We want more no votes on the motion, which in essence is a yes vote for our bill. So just so you know, if we get a second for the motion, which I'm sure we will by Odenbach or Stevens, then they're going to be voting on the motion. They're not voting on the bill itself. They're voting on a motion to basically move this bill to the 41st day of the calendar. Since there's only 40 days, that kills the bill. So just to give you an idea what's about to happen in a minute.
I don't think the changes are necessary, and I would encourage you to vote to put this bill on the 41st day.
Charles, it's just an indirect way of killing bills.
Thank you, Mr. Chairman. I would like to start out by saying I think the video of this testimony or of this whole hearing this morning would be probably the best thing you could show new couples in marriage counseling sessions, and I think maybe we ought to find a way to do that. Wow. I want to commend the proponents of this for the focus that it brings on fatherhood issues. I think there's no greater issue that we may face foundationally.
If they vote on the motion, we want no votes on the motion. We want yes votes on the bill. But if somebody seconds the motion, then we're going to want no votes.
Maybe some of the things that have come out here could provide the basis for a resolution of the House or something like that to provide more direction or training, if you will, to judges to look closer at this from the perspective of the dads, frankly, in these types of disputes. But this is a really tough one. I've heard from a lot of judges and a lot of attorneys I've reached out to over the last few weeks on this, who I respect greatly. And I will have to go with their recommendations on this motion. But I think, as Representative Stevens said, he used the term "this changes the focus," and that's maybe okay. And it's something that I want to continue looking at. If this does change the focus on into fatherhood and into a mechanism that makes both sides realize they are going to have to work together, that is truly in the best interest of the kids. So I want to thank you for bringing this and for continuing to work on it. So just wanted to say that. Thanks.
Thank you, Representative Odenbach. Further comments on the motion to defer House Bill 1052 to the 41st day? Representative Pischke.
I'd like to make a substitute motion of due pass.
Is there a second? Motion made by Representative Pischke, seconded by Representative Aylward to send House Bill 1052 to the floor with a due pass recommendation. Comments on your motion, Representative Pischke.
Thank you, Mr. Chair. Well, the good representative from Yankton, I agree with a lot of.
So now we need to pay attention. Are they voting on the motion or the substitute motion?
A rebuttable presumption. We made it like this is some scary thing. I believe I don't know how many times in our code. I haven't done the research on this, but a presumption is something that's all throughout our code. In fact, I believe our judicial system is built on the bedrock of a presumption of innocent until proven guilty beyond a reasonable doubt. So I don't think that the words presumption should be something that we're scared of. I think it's a good thing. And you've talked about how you don't think that judges are starting with a 70-30 or starting with a 60-40 right now. You think that they're starting with 50-50. That's great. Why don't we codify that then? We are the legislative branch, and we make policy for the judicial branch. We make law that tells the judicial branch how to apply the law. And they apply the law. So I don't think that saying that a presumption is anything to be scared of. I think that's something that we can tell the judicial branch that that's how we want to handle these cases. We heard some of the opponents even admit that the system is currently broken.
Yeah, he's doing great,
Zach.
Zach.
Came up and said that she went through divorce divorce, and that was with the current system that we have now, and it's currently broken. We need to do something to fix this broken system, and we're seeing the results in Kentucky.
Representative Tom Pischke is speaking now.
Violence is going down. We have more kids that are happy. So I think that this is the right course of action that we need to take here in South Dakota. So I'm not going to pile on, I guess, but that's my motion. Thank you, Mr. Chief. Thank you, Mr. Chief.
Thank you. Further discussion on the do pass motion. Representative Schwach.
Thank you, Mr. Chair. Well, I've been looking over this, and I've been kind of struggling with Section 1 and Section 2, and I've been trying to make sense how they're going to work together. And so Section 1, talks about a rebuttable presumption, and what that is in our code is it's a presumption imposed on one party who has the burden of going forward to prove that evidence, that joint custody.
I think he's the one who killed it last year.
Of the child. And this presumption under Section 1 has to be overcome, or there has to be so much evidence presented that it's substantial, credible evidence. And like a good colleague from the best district in the state, Representative Stevens pointed out, he doesn't necessarily know what that means. And I don't know what that necessarily means either. But I do understand that that's a high burden.
Yes, he's an attorney,
then
Susan.
I look at Section 2, which says that the first line is new, which says that the court will determine appropriate physical care, custody, and control in accordance with Section 25-4A-21. Okay, so that's telling the judge, when I read 25-4A-22, I need to go back to 25-4A-21, which again creates this rebuttable presumption of joint custody that must be met with a high amount of, that must be overcome with a high amount of evidence. Okay, then I go back to 22, and it says following the considerations of factors set forth in 25-445.5, and I go to that, and that talks about domestic abuse and assault convictions and how those work. And there, it also creates a rebuttable presumption that if any of those things are showed up, a conviction of domestic abuse or a conviction of assault or a history of domestic abuse, then joint custody is not in the best interest. But that standard is just greater convincing force of the evidence, which is preponderance of the evidence, which just means more likely or not. So by passing this law, as I read these two sections together, we're creating a lot of confusion from judges, and what I'm concluding right now and looking at it is that a woman suffering from domestic violence has a higher burden to show joint custody than the abuser does to beat back a case of domestic abuse or a claim of domestic abuse. And that seems wrong to me. I see you look on your face, you're squinting. It is confusing, and I may not have and I didn't articulate it very well. And imagine being a judge in the situation where you have to try and figure out all these interweaving standards of evidence going on when you've got a kid's...
Yeah, technically I think he's the guy who killed it the last 2 years. When I was up there in person, he killed it that year too.
So I urge you to resist this motion. I think it's confusing here in this language at best, and we should just send it to the 41st state.
Thank you, Representative. Further discussion on the do pass motion. Representative Pischke.
Thank you, Mr. Chair. Well, to be honest with you, this language for the presumption or the substantial credible evidence language, that came from working this bill last year. And the good Representative, now Senator Johns, helped me with this language. And he thought that for civil cases, it should be the substantial credible evidence. So that's where the genesis of that comes from. I don't know what that exactly means. I'm good. If we wanted to move this standard to the preponderance of evidence, I was acceptable. That's acceptable to me as well. But I would think that somebody knows what substantial credible evidence is, because this law has been codified since 1979. So I think that there's got to be some kind of evidence as to what substantial credible evidence is.
Thank you, Representative. Further discussion on the do pass motion. Representative Rayfeld.
I just have a couple comments in regards to kind of how I've gone into my decision making in regards to this bill, which I think we can all agree is very difficult. And what I kept coming back to is really what is our priority and what should be our priority. And that's our kids. So for me, I have a 3 and a 5-year-old, and I can't imagine the difficulty that you go through when you go through a custody battle. And it makes me emotional to even think about it. So I feel very sorry for those of you that have those difficult scenarios. I do. I feel very sorry for you. But the bottom line for me is that we have to be thinking about what is in the best interest of them. And I don't believe that we can legislate having parents get along. I don't think we can do that. And I think that that is what this is trying to do. It's trying to force people to get along. And we know that that's not possible. The other portion of this that makes me really hesitant is that the data that we're hearing about 50-50 parenting comes from 50-50 parenting where that's a choice, where it's not forced. That's all I have.
Representative Boyer.
Well, I think we all have an agreement that we want families to stay together. It's not a disputable fact that a child needs a mother and a father in their home. Being a new mother, I'm very, very blessed that I have a partner and a husband that we could both raise our child. But not all families can stick together. Not all families have the ability to live healthy, functional lives. I don't think that this is a bill that would promote healthy, functional families. I think it will undercut the ability to have abused parties, parties that just want to get out and seek a better life, a better situation. We've already heard that would create a burden and make it 10 times worse than 10 times harder than it already is. And I also want to be clear that custody laws and the laws on the books does not cause domestic violence. Laws on the books does not cause families to break up. We could already do shared parenting. Those who can do shared parenting can already do it. So for this reason, I ask you to vote no on the do pass.
Thank you, Representative. Further discussion on the do pass motion, Representative Barthel.
Thank you, Mr. Chair. I'll keep it quick because there have been a lot of great comments said so far this morning, but I just go back to one statement that was said earlier in testimony, and that is the judge represents the child, not the parents, the child. My fear is we're going to tie the hands of the judge and remove so much discretion that who's going to represent that child going forward. So I'd ask you to resist this motion. Thank you.
Thank you, sir.
Okay, that's not a good sign, guys, unfortunately.
Thank you, Mr. Chair. I just wanted to make one comment on the presumption because there's a lot of confusion. What exactly does this mean? If we don't have a clear standard of what this means, then we shouldn't pass this. I think one of the most important things that you learn in law school is that the answer to any legal question is it depends. That the law is not exactly black and white because every situation is different. And so we're never going to be able to find a set standard that's, okay, if A, B, and C are there, then yes. It's up to the arguments that are put forward. It's the reasoning of the judges and the parties. And so there's never going to be a clear defined line. And so I personally don't have any problem with this presumption, and I will be supporting the bill.
Thank you, Representative. Further discussion on the do pass motion? Any further discussion?
Okay, so we want yes on the do pass
Seeing
motion.
No further discussion. The motion before the committee is to send House Bill 1052 to the floor with a do pass recommendation. All those in favor of the do pass motion will say aye. Those opposed, nay. Madam Secretary, please call the roll.
Representative Elward,
Aye.
Barthel,
Nay.
Schwach,
Nay.
Odenbach,
Nay.
Peterson, nay. Fischke,
Aye.
Poirier,
No.
Rayfeld, no.
Shoot.
Reimer,
No.
Crud.
Soy.
That's it.
aye. St. John,
Aye.
Stevens,
Nay.
Shoot. So it doesn't pass this year.
Aye.
Crud.
We have 4 yeas, 9 nays.
That motion fails. We're back on the 41st day motion, discussion or action. Okay. Madam Secretary, I believe it was 8-5.
You're correct. I apologize.
Thank you. We're back on the 41st day motion. Any discussion on the 41st day motion? Seeing none, the motion before the committee is to send House Bill 1052.
So this one we want no, but they're going to end up getting 8 yeas.
All those in favor of that motion will say aye. Those opposed, nay. Madam Secretary, please call the roll.
Representative Aylward?
No.
Barthel?
Aye.
Schwach?
Aye.
Odebach?
Aye.
Peterson?
Aye.
Pischke?
No.
Poirier?
Aye.
Rayfeld?
Aye.
Reimer?
Aye.
Yeah, so it's
Soy?
tabled.
No. St. John? No.
Even though I know it's disappointing, we are getting more and more hardcore people supporting us in the chamber.
We have 8 nays, 5 yea.
Thank you, Madam Secretary. That motion carries. House Bill 1052 is deferred to the 41st legislative day.
So that means it's officially killed for this year. There's no way they can bring it back.
We'll move in our agenda to the next item.
Guys, we do want to thank Tom Pischke, Tamara St. John, Spencer Reitzman, Matt Doyle, Casey. I mean, just a huge team up there that did a great job this year. So I know it's frustrating for all of us, but they did make a lot of progress behind the scenes. So now we need to focus on Missouri and Texas, Georgia. Missouri, we've got some big things coming up. We don't want to announce them publicly yet because we don't want it sabotaged. Texas group is doing a phenomenal job. But if you guys get a chance, send a message to South Dakota for Shared Parenting, letting them know how much we appreciate them. Let Tom and Spencer know how much we appreciate them. Thanks, guys.